May please, Lordship.
Yes.
My lord, I think.
Oh, just a moment. Let me start the day with a mention. Mr. Mubarak. I can only wish that you would send a representation to the parliament to amend the CPC.
Me too, my ignore is smiling.
I don't know, you are asking for bail under 151 CPC.
Lordship,
So we can only
I beg your apology.
We can only hope that you send a representation to the parliament. Maybe they will amend CPC. I can't do anything. It's been adjourned.
Lordship, I may be allowed to correct.
You have to do it to the registry. We do it as you want, but we can't do anything. You can't do anything. Yes, next. Yes, Mr. Mahmood. Now,
My lord, Lordship, can you amend the first title? My lord?
just item 29.
Lordship. Can I amend the Lordship first title?
We'll have to go to the registry and do it because they'll have to correct the central registry. You know the system now. We'll send it. You do whatever you can do. Yes, Mr. Mahmood.
My lord, 3 items have come, so item 1 may kindly possible for the day, and 27, 28 I will do one. There are some similarities, sometimes we become puzzled. 27 and 28 I will do, but 1 may kindly possible for that. After
Okay.
vacation.
One, both sides are represented on the prayer made by Mr. M.B. Mohammed, counsel for the petitioner. List after ensuing long vacation.
I love that.
Yes.
May it be the Lordship. My lord, I'm praying for a habeas corpus, my lord. It was listed on 23/9 before my lord Justice Jayan, this Manoj Patel.
You could have done it yesterday, but today you see.
My lord, then it was fixed on, it came up on 110. Then it was told that it will, because it could not reach before the court, so it was told that it will be coming in the.
Today is a very uncomfortable day.
Because,
to
my
take
lord,
up a-
wrongful confinement of a man for such a long period, my lord. Again, another,
Foreigners matter.
that foreigners matter, my lord, then he was.
So why are you filing a habeas corpus?
Because my lord, of the same name, I am not under a reference. Of the same name, somebody has picked me up. The police called me upon and they said you go inside the jail.
That will require
Hearing
some
at some length.
Because
adjudication to
well, the
decide whether,
report was called upon. And
no, whether you are that person or a different person will
Because
require some
we
adjudication.
we have placed some documents, my
No,
lord.
but you see, today is a very uncomfortable day.
Is there a report from the police to say that there are two different persons?
Report was called upon, my lord. Report was called.
No,
Will not be
report was
aware.
not called, Lordship, but
Record.
record.
They will not be aware. Without a listing, they will not be aware. They will not go through the file.
You should have mentioned on first. If it was not there.
No, first it was listed, my lord,
Ah.
but it could not reach before this court.
Very good. No, now today, what are we supposed to do? Even if we get the matter listed, they will not have the instructions, perhaps.
Maybe. Let it be on 21st, my lord.
Ah,
Let it be on 21st.
21st. Okay. Give the mention memo. We'll give the mention memo.
My lord.
Lordship, I beg to mention item number 2. In this case, Lordship petitioner expects some certified copy of the voter list that is yet to receive, and thereafter she has to file a affidavit, Lordship.
Okay,
After
both sides are same order. Item 2. On the prayer made by Mr. L.R. Mazumdar. Same item number 1. Okay. Yes, next.
Lordship, after 4 weeks. All right.
John,
This is
after
Lordship.
4 weeks.
With the concern of the other side, I'd like to mention item number 9 and 10. As my senior is out of station, can the matter be taken after vacation?
9 and 10. Okay. Same order. On prayer made by line counsel for the petitioner. What is your name?
Ardas. Ardas.
Ms. Ardas. 9 and 10. Okay.
May I please, your Lordship? Lordship, I beg to mention item number 3, Lordship. Lordship, in this case, matter has become infectious. Victim already recovered, Lordship.
Item 3.
Yes, Lordship.
Okay, three would be you will pay.
Lordship, victim has already been recovered, Lordship.
Okay, both
No
sides are,
liability.
both sides are represented. Next, for upon instructions, Miss
A. Ahmed.
A. Ahmed, learned counsel appearing on behalf of Mr. M. Mandal, counsel for the petitioner, submits that the alleged victim is recovered and therefore she has instructions not to press the matter.
Yes, right.
Mr. R.K.
R. Talukdar.
Mr. R. Talukdar, government advocate appearing for the respondents is present, state respondents is present. Full stop. He submits that he also has instructions that the victim, alleged victim is recovered. Next para, accordingly, the matters is rendered infructuous. Full stop. Therefore, comma, the matter stands closed on satisfaction.
I.
Yes. You are there?
Yeah.
You also write, Mr. for the government advocate, Mr. D. Nath, senior government advocate, along with Mr. R. Talukdar.
Yeah.
Yes. Any document is there?
Lordship, in fact, we have filed
In our affidavit,
Affidavit.
kindly similar the photographs. Kindly similar at page
Just give it. We
43.
don't have the file right now. Just pass it
Sure.
over.
one copy we can.
You add also.
Did-
You also add one line. In his submission, add one line. In this regard, he also refers to the affidavit in opposition filed by the state respondents, which also contains a photograph of the alleged
Well, kindly see page 41.
alleged
Photograph.
victim.
Photograph.
Along with parents in a at police station.
Along with her parents.
Paragraph
Which was taken on 9/9/2024, along with
Check post.
location. Showing the location which is with latitude and longitude in front of Halakura, HALAKURA police checkpost at Dubri. Okay.
yes.
Okay. We just wanted this because it's a habeas corpus. She's not on record.
Correct. Page 41, 42, and the paragraph 8 is our statement.
It's okay.
Oh, blah, blah.
Oh, Mr. Mandal is there. You see, write the name of Mr. Mandal. Any Mandal for the petitioner instead of A. Ahmed. Huh?
She's come back to you or she's gone back to her parents.
Under
Button up your
this
coat.
case, she
Mr.
was
Mandal,
forced to.
button up your coat. Button up your coat.
Yes,
Coat, button.
Yes.
Huh. Yes, what do you say?
but after lodging this case, she was compelled to live with me.
Interesting. Next.
Obliged, sir.
Go ahead.
Daily list upgraded item 14.
Not legal. Yes, there is a miscase for condemnation of delay, my lord.
And a similar situated person, sir, may come before challenging this order, and honorable division bench already passed an order, so by some observation, my lord. Page 36, man, 361 in my writ appeal, my lord. 493 days delay, my lord. Because of that, my lord, my lord. My lord, the main application is that, my lord, 3 persons are leading, my lord, case, my lord. So many cases are by petitioners are there. My lord.
What do we understand with the term glass appointment at page 18,
My lord.
6 lines from below?
Oh, my lord.
He has been advised to be under rest and to come for glass appointment after 1 month.
My lord, as per my lord, medical, my lord, term, my lord. Medical.
Medical term. Okay.
My lord, because of that, there is a severe, my lord, in my lord, I, my lord, in Chennai, my lord.
Good. Mr. N. Bora, learned counsel for the applicant. And Mr. R. K. Talukdar, learned government advocate appearing for the state respondent number. Oh, no, he'll not be there. No, don't write.
Education.
Education.
Anyone for standing council education?
Education. Yes, education.
Mr. Sharma is.
Okay.
Education.
Mr. Sharma, you are appearing for education?
For elementary law, sir.
Okay. Mr. P. N. Sharma, learned standing counsel for the elementary education
Education
department,
department.
representing respondent numbers.
Responsible. One.
Two, you are not for one.
One is for secondary education. I can appear for both.
Oh, you can both.
Lots of lots.
Then he will appear for 1, 2,
6, 5,
6,
8,
7,
and 9.
8, and 9. Next, you should notice on this application under section 5 of the Limitation Act, seeking condonation of delay of 493 days beyond the period of limitation in filing the connected appeal. Next paragraph. The learned counsel for the applicant shall serve requisite extra copies of this application to the learned standing counsel for the education department, as well as to the learned standing counsel for the finance department. In respect of respondent numbers 3 and 4. In 2 weeks. Next, affidavit in opposition will be filed with this 2 days prior to the next date of listing. Next list after 4 weeks on a date to be fixed by the office, by the registry.
Absolutely. The next is. Well, next is also same, man.
Hmm?
Next is also same.
Next item.
Oh, man.
Okay, same. 493 days here also.
487 days.
487 days, same order.
March.
Same glass appointment.
No, actually, all are coming in the repetition, but they are left out, my lord. And already that against their order, and all division bench pass an order, my lord. If I am not coming, my lord.
To come to glass appointment, I think so.
Prescription
Prescription to wearing
glasses.
glasses.
March.
My brother has rightly said, if you had an eye surgery, it would be, he had an appointment for prescription glasses, not glass appointment.
I'm sorry.
It is prescription glasses.
Prescription. What's it?
Anything here and there catches our eye. Anything which is not in sequence catches the eye.
Supply item 29.
Okay. Mr. A. Mubarak, Learned Counsel for the applicant, is to permit him to make necessary amendment in the cost title. Most of prayer is allowed. The same may be done in the concerned section of the registry. And thereafter the matter be listed before the court.
Amended cost.
Under, Lordship, we have take care of.
The amendment of the cost title and thereafter file amended cost title. After amendment, they have to file amended cost title. So only that correct the language. Okay.
Lordship, under which section I will define
Huh?
under which section my note I can find my note?
You're
we are
asking for
sorry.
legal advice.
We are sorry, we both left that
Our
provision.
days of legal advice are gone.
Gone.
We can't give you legal advice. We can pass an order.
Supply item 30.
Yes, Mr. Upadhyay. What is this matter about?
This is the bail application, Your Lordship.
And CGC, Mr. AK Heard Mr. R. Sharma and counsel for the petitioner. Also heard Mr. G. Sharma and standing counsel for the Home Department representing respondent numbers
2 and 4.
2 and
4.
4. Mr. R. Talukdar, Leonard Government Advocate appearing for respondent number 5. Mr. A. K. Datta, Leonard CEK appearing for respondent number 1. and Mr. M. Kudi, learned counsel appearing on behalf of Mr. A. I. Ali, counsel for respondent number 3. Next, brother. The learned standing counsel for the Home Department shall take instructions for appearance on behalf of respondent number 6. Next, brother. The opinion dated 22/4/2019 passed by the member, Foreigners Tribunal, 7th, Sonitpur, in FTDC case number JFTDC 412/16, by which the petitioner was declared to be a foreigner of post 25/3/1971 within the meaning of section 2 within the A of the Foreigners Act of 1946 is sailed by filing this writ petition under Article 226 of the Constitution of India. Next, issue notice returnable in 4 weeks. So requisite extra copies of the writ petition be served on the learned State and Departmental Council within 2 weeks. Next, the petitioner shall take steps within 2 weeks for service of notice on the respondent number 6 by registered post with AD. Next, brother. In the event the petitioner has not been deported out of India, he shall not be deported out of the country without the leave of the court. Next, brother, list after 4 weeks. Before that, you write the prayer for bail shall be considered on the receipt of the tribunal records. You produce the copy of in the net, it is not coming up. The Uttar Pradesh rules for the registration of birth. You have registered a 1958 birth in 2016.
Yes.
So you show this rules because we are unable to download in our tab. It's not coming up. There's a 2002 rules. 2003 rules does not exist. There's a 2002 rules. 2003 there is an amendment of section 8, rule 8, but we are unable to download. Okay. Mr. Upadhyay, we are issuing a notice in this Mr. Upadhyay's matter.
Yes.
In the writ petition, it is corrected as Borpeta. It's there. Oh, अच्छा. या तो हमारे पास कोई आई वो लिस्टिंग तो वहाँ नहीं हमारा सीएस सिस्टम में आई वो
PPC is listed.
listed. No, 50 things. Mr. N.N. Upadhyay, learned counsel for the petitioner. Respondent counsels will be same. Date of opinion is 11/1/2022 by the foreign member Foreigners Tribunal number 6, Borpeta, in FT case number 689 of 2016. Rest of will be same. Notice on respondent number 5. And also say the same thing. He'll take instructions to appear on respondent number 5. Saying he shall not be deported out of India. Call for the records. We've done it.
NCR.
We call it.
Item 5.
Yeah, I believe you'll also. My lord, the petitioner, my lord, exhibited, my lord, 16 numbers of documents, my lord, including, my lord, 1934-35 Tiras Patta, and my lord, voter list of 1966, 1971, and my lord, his elder brother, he deposed as DW2, and his name and his father's name appeared in the voter list of 1966. That is page, my lord, 30.
Page
30, my lord. Alimuddin is his father, and Naib Ali is the elder brother who deposed as DW2, my lord.
both deposed. Both of them deposed.
No, my
Your
lord.
father.
Father expired.
Oh, acha.
Naib Ali.
Naib Ali. He
Yes.
deposed of
He is
the
the elder brother. And my lord, the DW2 and the petitioner, their name also, my lord, appeared in the voter list of 1985.
Mr. Sharma, his brother has deposed his father's, along with the father, the voter list is there. We are giving him bail. But Mr. S. A. Ahmed, counsel for the petitioner. Also heard Mr. G. Sharma, the understanding was for the Home Department, representing respondent numbers 3 and 6. And Mr. R. Talukdar, learned government advocate, appearing for respondent number 5. Mr. H. Kuli, learned counsel, appearing on behalf of AIRA, standing counsel for the ECI, representing respondent number 2. Next, the learned standing counsel for the Home Department shall obtain instructions for appearing on behalf of respondent number 4. Next, the opinion dated 29/12/2023, passed by the learned member, Foreigners Tribunal, within bracket 3rd, bracket closed, Darang, Mangalai, in FT within bracket 3, bracket closed, case number 6251 of 2021, declaring the, whereby it was opined that the petitioner is a foreigner of post 25/3/1971 under the Foreigners Act, 1946, is assailed by filing this writ petition under Article 226 of the Constitution of India. Next paragraph. Pursuant to order dated 8/4/2024, the records of the tribunal is received. Full stop. It is the same. Next paragraph. On the perusal of the records, the court is inclined to issue notice returnable in 4 weeks Requisite extra copies of the writ petition be served on the learned state and departmental council in the course of the day. Next paragraph. The petitioner shall take steps for service of notice on the respondent number 4 by registered post with AD within a week, within 2 weeks. Next paragraph. In the event the petitioner has not been arrested, comma, on his appearance before the superintendent of police within bracket border,
Torong matter.
Darang, within 10 days from the date of the order, and on furnishing a bail bond of rupees 5,000 with on the said authority shall grant bail to the petitioner. It's standard order. Next paragraph. List after 4 weeks.
Obliging.
Item 6.
Maybe we will also.
Lordship will find the impugned order at page 52.
Last time we had asked you a question. The challenging 2019 order now. Where is the service book of your father?
My lord, yesterday I have filed additional affidavit annexing the service book.
Not on record.
Not on record.
Affidavit is not on record.
Okay.
Let it come after the vacations, along with the affidavit. Yes.
Next time, F, Hawk Leonard Council to the petitioner, F Hawk.
Yeah.
PA on the Learned Council for the petitioner. Submits that an affidavit has been filed on 3/10/2024 to bring on record the service book, photocopy of the service book of the petitioner's father. So the same is not available on record.
Here, original service.
But it has to be there. We have to appreciate that. Just see, let us see that.
The school certificate of his father also there.
No. No, no, consider that. As well.
Reference was made in as a daughter of Asghar Ali.
Asghar Ali. My lord.
My lord, because I think so.
What is- All right, then,
We are satisfied with this record. We are issuing a notice. You want to,
our-
this is last day, we are not waiting.
Mr. P. A. Ahmed, learned counsel for the petitioner, Mr. G. Sharma appearing for respondent number 3. 3 and 6.
Yes, Lord.
5 and 6. 3, 5 and 6.
3, 5 and 6. Yes, Lord.
Mr. A. Dotto for respondent 1. Union.
8 also, Lord.
8 also.
3,
Okay.
5, 6.
Mr. G. Sharma for 3,
5, 6, 8.
5, 6 and 8. Mr. A. K. Dotto for respondent 1. MS Bedi.
And Bedi.
N.
N Betty.
N. Bedi. Appearing on behalf of Ms. MS P. Barua for respondent number 2. Mr. Talukdar for respondent number 7. And okay. State is appearing for nodal officer also. NRC.
No, no, Lord. Then that instruction I have to take, Lord.
This petition is filed with the petitioner putting to challenge the opinion order dated 26/04/2019 passed by Member Foreigners Tribunal, Bongaigaon number 2, Obhaipuri in PNG/APR/case number 96 of 2016. Stop the tribunal by the said opinion. Answer the reference preferred by the state under section under the Foreigners Act 1946 in affirmative, and held that the petitioner is and declared the petitioner to be an illegal migrant belonging to the 2503/1971 stream, who had illegally entered into the territory of Assam/India. Stop. Para, upon hearing the counsels for the parties, let the records of this tribunal connected to so-and-so case number be called for. Stop. Matter be listed immediately upon receipt of the records on a date to be fixed by the registry. Stop. It is also submitted by the learned counsel for the petitioner that an additional affidavit has been filed yesterday
On 3,
on 3/9,
3,
3/10/2024. Stop. The same is not available on record. Registry to verify and connect the same to the case record by the next date fixed. Since the respondents had already entered India, extra copies will be furnished within a period of 2 weeks. Yes. You are supposed to pay. Okay, you want a bail, but you did not ask for it. Within 10 days, will appear before the so-and-so ordered SP by furnishing a bail bond of ₹5,000 with one local security like that. And biometrics and fingerprints along with all information will be required. Yes, 10 days. Yes.
Item 7.
May please your lordship. Lordship, this is a matter pertaining to a girl from Myanmar, lordship. and she was lodged in the detention center, Lordship, by the Deputy Commissioner Kamrut. And in terms of the order of this honorable court, the girl has been conferred with the refugee status, Lordship. This is the I-card. Yes, sir.
Oh, this is recent.
Yes, in terms of the order of this honorable court, they taken up
It's
the
not,
matter.
not in terms of the
There was no direction.
order. There was no direction. In fact, there was a direction to facilitate the
Yes, sir.
process.
Processing the claim.
Yes.
That's all.
Actually, I wanted to say so, Lordship.
There was no direction to declare the person as a
No, Lordship,
refugee.
no.
So what happens after the person is now directed, declared as a refugee?
As the person has been declared a refugee by the Lordship.
Mr. Hussain,
Lordship.
when you are showing us this document, the document in our eyes has no value. Can you tell us why?
That is a photocopy, Lordship. Photocopy to person. May not be so.
You know why?
Because this is a photocopy, Lordship, and besides it has been transmitted from mail.
No. The difficulty between you reading and us reading is totally
Yes.
different.
I admit, Lordship.
You see, here there's a, in the right hand side, there's a column, I hereby acknowledge receipt of the refugee card. It's not signed by her. So she has not accepted the refugee status as yet.
That is a technical issue there.
I don't know. Yes, but it is
Done now.
Uh,
Close it.
It's maybe closed, Lordship, and she may be released from the detention.
No,
Lordship.
that is another aspect of the matter, and for that purpose, Lordship, when it was before court number 5, Mr. Anjan Kalita, he has been appointed as an amicus. Now, what happens is, admittedly, the petitioner has come from Myanmar. Now, there was a case, initially the NIA thought that she was involved in trafficking, but later on it has come out that she is one of the victims. She has given her evidence before the NIA court. Now, the question is, what happens after this? How do we deport the petitioner, or what happens till that time when we cannot deport her?
This is not even a prayer, no? Her prayer is to
I,
process her,
no, that is that apart.
so that
If
the
the
end of the
lordship is
matter.
going through the prayer, lordship, I got nothing.
That's all. Because they say that the card has been, their status has been given that of a UNHCR
But from
refugee.
for release from detention, that is.
that they have not prayed for.
Lordship, there is a prayer also in the at page 13, Lordship.
You have prayed for,
Yes, Lordship.
but then you are not pressing it now.
No. As actually initially the court as well as we were concerned on the refugee status, Lordship.
Okay.
And thereafter this part.
no, because otherwise also under the law,
Lordship.
you have to be within the confines of a detention center because you can't be allowed to roam freely under the act. So you have a refugee status, but you will not be deported. That's all. You have that only that protection.
There is a camp, detention camp at Telangana, Lordship. There actually wherein her relatives are staying. And we are specifically instituting the prayer, Lordship. And there is.
Where are you now?
I am in Matia camp, Lordship.
The government will consider it. your
Matia
prayer.
camp,
No,
Lordship.
that would be for that state to consider, because the detention camp is in Telangana. So
You
at best, what we can do is we can facilitate the,
facilitate,
and if they accept it, because there was a prior case where the petitioner wanted to go to Kashmir. And Kashmir government said that we cannot, it's already overcrowded. So that has to.
We give you liberty to apply and the state,
Yes,
because Telangana state is not within our jurisdiction. We
Yes,
can't do anything.
yes, Lordship.
We can't even give a direction. We can only say that this, if a representation is made,
That will be a process.
the state in consultation with the Union of India
Yes,
will
sir.
facilitate
Yes, yes.
transmission of the request
can
to
be
the
done.
appropriate authority.
That can be done.
Is there any information as to the space available in that Telangana temple?
Lordship, I do not. यहाँ के सब ये तो আছে না paragraph 15
Evidence,
yeah ভাই তো হই গল paragraph 15 to পড়া
Mr. Hussain and Mr. Chaudhary,
No,
I'm just thinking aloud,
yes
should it be appropriate that if they make an application
Yes,
to
yes,
to the detention center,
yes Lordship.
then the state government and you will facilitate transmission of the
Yes
request to the competent authorities in Telangana.
yes that can be done Lordship. That can be done.
You have not filed any affidavit that refugee status has been granted or anything, nothing.
No, Lordship, this is,
Well, we'll record your statement and we'll keep a copy of this.
yes, Lordship. Yes, Lordship, that can be done. It has come to us through mail, Lordship, by the UNHCR.
My lord, he will give us a copy.
Yes, I shall.
Heard Mr. Zaid Hussain, learned counsel for the petitioner, Mr. RKP Chaudhary, learned DSGI, appearing for the respondent number
1.
1. And Mr. J. Pine, appearing for respondent number 2, 3, 4, 5. Mr. R.K. Talukar for respondent number 6. The petitioner before this court claims to be a national of Myanmar belonging to the Rohingya community. Stop. Because of communal violence, the petitioner claims to have been compelled to cross international borders to reach the United Nation High Commission in New Delhi, seeking a refugee status in India. Stopped. She entered from Myanmar, she entered into the territory of Bangladesh, and thereafter she entered Tripura and subsequently in Assam. Stopped. On 25/07/2021, the petitioner, along with other such refugees, while were traveling in Agartala-Deoghar Express from Badarpur is in Kachar.
Yes.
Badarpur in Kachar to New Delhi via Guwahati, in their attempt to reach the United Nations High Commission in New Delhi for seeking the refugee status. Stop. On their way to New Delhi by the said train, the petitioner along with others were apprehended by railway police personnel at the Guwahati railway station, and an FIR was lodged against the petitioner and others by the Guwahati GRPS case number 67/2021 under section 120 within bracket capital B/370/371 IPC read with section 14 of the Foreigners Act, COPA, and section 4 of the Passports Act, the Passport Entry into India Act 1920, and Rule 6 of Passport Entry into India 1950. Stop. They were forwarded to judicial custody on 26/07/2021. Stop. After completion of the investigation, the charge sheet was submitted, and in the said charge sheet, which was filed on 22/10/2021, the petitioner and 9 others were not found to be involved in the said offense. Rather, they were found to be victims of circumstances who became an easy prey for the human traffickers. Stop. Upon perusal of the said charge sheet, the special judge, learned special judge NIA on 25/10/2021 ordered that the petitioner directed the petitioner not to be put up for trial, and they were released on personal bond. Stop. Subsequently, on 28/10/2021, the learned special judge NIA issued a direction to the DC Kamrup within bracket Metro Guwahati for making sufficient arrangement for the petitioners to return to their respective places. And also for their safeguard in order to expedite the trial for completing their evidence. Stop. Pursuant to the said order, the DC Kamrup Metro made arrangements for the petitioner to be detained at the Matia Detention Center at Gwalpara. Stop. Presently, the petitioner is still in detention at the said center. Stop. The statement and evidence of the petitioner has been recorded in the proceedings before the NIA court, but in spite of that, the petitioner has not been released from detention center by the respondent authority till date. Stop. Being agreed, the present writ petition has been filed. Stop. Learned counsel for the petitioner submits that the prayer made in the writ petition is for permitting / facilitating the writ petitioner to be released from the detention center and to be relocated to the refugee camp number 11, Royal Colony, Ballapur, Hyderabad, Telangana, as other similarly situated persons who had traveled together with the petitioner are lodged in the said detention center. Stop. Para. This court, by earlier order dated 18/07/2024, permitted the respondent authorities to complete their instructions, and also appointed an amicus curiae, Mr. Ranjan Kalita, advocate of this court. Stop. Subsequently, when the matter was listed on 21/08/2024, on the basis of a communication dated 19/8/2024, received from the Inspector General of Prisons, Assam, as well as a communication dated 20/08/2024, issued by the Joint Secretary, Government of Assam, Political within bracket capital B bracket close department. That, to the effect that during the period of the detention of the petitioner at the detention center, United Nations High Commissioner for Refugees, within bracket UNHCR bracket close, representatives have gathered information and evidence in respect of the petitioner towards her claim for refugee status, and that they would review the case and take a decision in the matter. Stop. The said communications were kept as a part of the record of the case records, and the matter was deferred, permitting the respondents to complete their instructions with regard to the claim of the petitioner for grant of refugee status by the UN. A copy of a photocopy of the UNHCR receipt for refugee card shown to have been issued to the petitioner, namely Rashida Begum,
Sure, sir.
daughter of Aminullah. Stop. Her date of birth is reflected as 1st January 2005, and the country of origin is shown as Myanmar, and this identity card was issued. Date of issue of the identity card is shown as 26 August 2024. Stop. Learned counsel for the petitioner submits that since the petitioner has been granted a refugee status under by the UNHCR, her prayer for being shifted from Matia Detention Center, Gwalpara to the refugee camp number 11, Royal Colony, Ballapur, Hyderabad, Telangana, should be directed by this court. Para. Mr. Counsel for the respondents, as well as learned DSGI, appearing for the Union of India, submits that a specific direction in respect of the prayer for shifting the petitioner to her preferred refugee camp as specified in the writ petition may not be ordered in the facts and circumstances of the case, and may not be ordered in the facts and circumstances of the case. Stop. Learned DSGI, however, fairly submits that the request of the petitioner for being shifted to the refugee camp in the state of Telangana, the request to be made, if any, made by the petitioner for shifting her from Matia Gwalpara in the state of Assam to the refugee camp number so and so in Hyderabad, Telangana, upon any such application being made, can be facilitated by the Department of Home, Government of India.
Ministry of Home Affairs.
Ministry of
Foreign
Home
Affairs.
Affairs. Secretary, Ministry of Home Affairs, Government of India. Stop. Para.
Foreigners Division.
Department of
Foreigners Division. Within bracket.
Department of Foreigners Division. Ministry of Home Affairs, Government of India. Para. We have given our anxious thoughts, we have given our anxious thoughts to the submissions made by the counsels for the parties, and have also carefully noted the pleadings available on record, as well as the photocopy of the UNHCR receipt for the refugee card stated to have been issued by the UNHCR to the present petitioner, a copy of which is retained in the case records. Stop. There is no doubt that the petitioner is an alien and is lodged presently in the detention center. Stop. The prayer for seeking a direction to transfer her from the detention center, Matia in Gwalpara, to her preferred detention center in the state of Telangana cannot be issued by this court, as the state of Telangana is not within the jurisdiction of this court. Stop. The Department of the Foreigners Division, Ministry of
Home Affairs.
Home Affairs, Government of India, is the appropriate department to look into the prayers, if any, made by the petitioner and facilitate issuance of necessary orders by the union or by the respective states upon such an application being preferred by the petitioner. Stop. Under such circumstances, we close this writ petition by recording the fact that the petitioner has been granted a refugee status by the UNHCR. However, that by itself will not be taken as a ground for being for considering her prayer for being transferred from Matia detention center in Gwalpara to her preferred refugee camp. Stop. The petitioner is given liberty to make necessary applications to the Ministry of Home Affairs as well as to the competent department in the state of Telangana. Stop. If such an application is made, it is expected that the respondent number one, the Ministry of Home Affairs, Government of India, will facilitate the state of Telangana, will facilitate the submission of any such representation before the state of Telangana and for appropriate disposal by the competent department. If and when any order is passed by the state of Telangana accepting the prayer of the petitioner for her transfer, then necessary consequential orders can be passed by the respondent number one, Department of Ministry of Home Affairs, Government of India. With the above observation, the petition stands closed.
So,
Copy of this order be marked to the office of the learned DSGI as well as to the Council for the Home Department, Government of Assam, for onward communication.
So, Lordship, there is a minor correction, Lordship. Badarpur is actually within Karimganj district.
Karimganj, Badarpur, Karimganj
Yes,
district.
yes. Deeply applied.
Item 8.
May I please, Your Lordship? The expiry order, Your Lordship. Page 31 is the impugn order. Page 31, it is the impugn order, Your Lordship. The petitioner, after appearance, did not appear in couple of days, and thereafter
Not couple, 4 days, 4 days.
Your lordship, 4 days. Page 32, your lordship, paragraph 4. Subsequently, the engaged advocate withdrew the Ukalatnam and proceeded ex parte, your lordship. Is that
What else can the tribunal do?
only humble limited prayer is that the matter may be remanded back and I will appear since I have all the documents.
How will you appear? Do you have a counsel now?
I will engage lordship. My father's name appear in 66, my name appear in 89 total story.
We'll have to call for the records first.
In the meantime, interim protection may be granted.
Yes, Mr. Pine,
Yes, sir.
call for the records. Mr. P. Roman, learned counsel for the petitioner, and Mr. A.K. Dotto for respondent 1, Mr. J. Pine for respondent number 2.
7 and 8.
7 and 8. Mr. Talukdar for, Mr. Hazarika for respondent number 6. And who's Mr. Kuli? K. Kuli. H. Kuli, sorry. H. Kuli for respondent number 3. The writ petition is directed against the opinion dated 2005-2024, passed in FT 340 of 2019, passed by the Member Foreigners Tribunal 7, Borpeta. So before proceeding further in the matter, this court would like to examine the tribunal records. Stop the registry to call for the tribunal records. And the matter be listed immediately after receipt of the tribunal reports. Since learned counsels have already entered appearances, formal notices will not be issued, but extra copies be issued. In the meantime, the petitioner will appear before the SP border, Borpeta within 10 days from today. And if the petitioner is not arrested in the meantime, he furnishes a bail bond of ₹5,000 with one local security of like amount. The petitioner will be allowed to remain on bail, not be detained and deported. When the petitioner appears, biometrics, fingerprints, address, etc. be recorded.
Hello.
Accordingly.
Item 11.
Madam, passport.
Go and if you go before the issue of nationals, that the council is different, you take steps. Of course.
उसी मीटर में भी पासवर्ड पर साइन नहीं होना चाहिए
But then, yes.
Mr. Payam.
Well.
In connection with that, that last matter, ex parte, what was there? Can you speak to somebody in the home department? So that, just like the High Court, we make the mobile number mandatory requirement for the every proceeding in the tribunal. Because then always an SMS can be generated and sent.
Yes.
So that the petitioner cannot then come up and say that, well, there was a disconnect between the proceeding and the lawyer.
We can, my lord, my lord, suggest, the government will definitely do it, my lord.
Because if
All the
they issue a
tribunals we can-
circular, then all the tribunals will now
Yes,
take
yes,
the
yes.
mobile numbers,
Yes.
just like in the High Court.
As and when, my lord, in the next date, everyone may be asked to submit their mobile number.
Yes. Try to
In all
try to
cases, when
think
there
in
is-
that line.
Yes,
When they file their WS,
yes, my lord. It
in
will
the
be yes,
WS,
it can be accepted.
uh,
And
WS.
even now,
evidence in
those where
affidavit-
the WS have been submitted, my lord, where those
No, WS, evidence in affidavit also.
Yes, ma'am. No, that's why, my lord, what my suggestion will be, and even in any stage, it can be suggested that it can be
Collected
submitted.
by the tribunal.
Because where they're already.
Preferably the first date.
Preferably in the WS first day itself. If it is not in the whatever stage it is, my lord, I can suggest for that, definitely.
And also, in those cases where there is a withdrawal of the power by a council,
Yes, that can be communicated.
communicated plus the tribunal can put the proceeding to notice
Yes, my lord, through SMS.
with a suggestion
Yes,
that there are legal aid counsels available.
yes. That I will demand. I'll talk to the home department.
That if it can be communicated, then we need not look into these matters.
Yes, my lord.
For
The
demanding it back.
expert.
Expert.
Definitely, I'll do it, madam.
So you first find out what is the situation there.
No, it can be, my lord. There is no issue. It's not a big issue, my lord.
Because as it is, when we are granting bail,
Yes,
their biometrics are recorded,
yes,
phone numbers, address, everything
yes.
is recorded.
yes.
So-
There also, they used to, my lord, grant
So-
bail on the first day itself.
So a transcript of that can always be communicated to the tribunal.
Yes, that can also be done. If it is there already.
It is already there. By the concerned position.
Or a simple circular, my lord, all the procedure will submit their phone numbers in the tribunal concerned. That will do. Yes, I can.
Yes, your item
My lord, item 11.
11. একটু করে নাও। Yes.
Impugn orders transform lordship case 31 lordship. This is a contested case lordship. And
Where is the evidence of your neighbor?
Lordship. Starts from page 49, Lordship. This is the affidavit in written affidavit, Lordship. And the cross part is at page 50. He is O'Neill Das, is it about 80 years? And another one, Lordship,
Where is your written statement?
written statement, Lordship. Page 26, Lordship.
We are only giving you interim protection for not to be deported. Because the finding of the tribunal appears to be correct. You see, you were born in 1964.
My lord.
You say that you were born in a particular village.
Yes.
Your father's voter's list of 1965 is of another village. You could not have been born there. Because you said that you were born in the father's own home. Father's own home is in one place. He can't be a voter in another place.
But
You have you have not been able to show anything.
but the petitioner has stated that his father went there for purpose of job, Lordship. And subsequent there to Lordship in the 70s, Lordship, in the 70s, 1970,
Nothing is available.
his father's name recorded.
You
Lordship,
see,
in the state
you don't go for a job to a village. You can go for a job to a better place. Can't go from one village to another.
No, even
village.
if you go, see, you must have noticed that on the date of casting vote, there are people from all over the world coming back
Right.
in their own constituency to cast vote.
Yes. That is in the year 65 voter list, Lordship, and he claimed that he
So
won
what
1 year prior.
my elder brother is putting a question is, even if you had shifted to the village for a job, your name in the voter list would be there where you are a permanent member.
Because Lordship, in the year 1965, the first time voter list. So
But your name is in a different village.
So therefore, you're a resident of that village.
But since 1971, continuously they are in the same village, and his name recorded with father also in the 1989.
So we are giving interim protection not to be deported for the time being. Bail will be considered on receipt of records.
I'm family praying, Lordship, bail may be also granted, Lordship, at this stage. Otherwise, Lordship, prima facie, Lordship, his father's name appeared in the year 1971 also in the same village, Lord. And his name also appeared. There is some discrepancies in the name, that's I admit,
So
lordship.
discrepancy in the name, we are not. mm,
And my lord, the witnesses are all elderly person and they have stated in the cross-examination also, lordship, that I am the son of that particular, my father, lordship, and I
But a
was,
neighbor can't say whose son you are. He is evidence,
he's a
not
neighbor
acceptable
and
evidence. None of your family members who are there.
none of the family members of the dear lordship, and
Hmm?
as I have stated in the written statement as well in it's my, he's elder than me, lordship, younger than me, lordship. I am the eldest among the brothers and sisters, lordship.
Okay. Heard. Mrs. J. Abbas, Land Counsel for the petitioner. Mr. J. Payang, Leonard, Standing Counsel for the Home Department, representing respond number 3, 3 and 5. And he will also take instructions whether it would be appearing for respondent number 7. Also had Mr. H.K. Hazarika Leonard, government advocate, appearing for respondent number 4. And Mr. A.K. Datta Leonard, CEC, appearing for respondent number 1. And Ms. Bedi Leonard, counsel, appearing on behalf of Ms. P. Barwa, standing counsel for respondent number 2. Next paragraph. The opinion dated 9/1/2024, page 2. These numbers are there, page 2. Before issuance of notice, the court is inclined to examine the records of the learned tribunal. So accordingly, let the records of the aforesaid proceeding be requisitioned from the Foreigners Tribunal -Roman 3, Borpeta, in FT case number 327 within bracket Roman 3 bracket closed of 2018. Next paragraph. You bid for rupees 5,000. Next paragraph. List on receipt of the records from the tribunal. Take a break and come back.
I think, well,
May I please, Your Lordship?
You're appearing as legal aid counsel.
Yes, Lordship.
What is the document which connects you to your?
Lordship, it's not cross-examined, documents were not proved. Initially, he filed his written statement, then subsequently on the same day, 15th of December, 2023, he has filed his additional written statement as well as his evidence on affidavit. Thereafter, date was fixed on 30th of January, Lordship, and he did not appear, and 2 dates, and then next date was 27/3 for argument. These two dates, there was miscommunication with the lawyer and himself, and as well as financial constraint also was there, Lordship, and the matter was decided at.
This is D. Ghosh, legal aid counsel for the petitioner. Also heard Mr. G. Sharma, standing counsel for the Home Department, representing respondent number 2 and 6. Mr. R.K. Talukdar, Mr. H.K. Hazarika, government advocate, appearing for respondent number 5. So, 5 and officer in charge.
Yes, Lordship, I am appearing.
For the
6 and 7, Lordship.
6 and 7 also. 5. Ms. N. Bedi, counsel, appearing on behalf of Mr. Ms. P. Barwa, standing counsel for the Election Commission of India. Next para, the learned standing counsel for the Home Department shall obtain instructions as to whether he would be appearing for respondent number 4. Next para. The opinion dated 28/5/2024, passed by the Foreigners Tribunal number 7th, Tejpur, Balipara, in case number FT DC 1723/2016. By which it was opined that the petitioner is a foreigner of post 25/3/1971 stream, was entered into the territory of India within Assam from the specified territory without documents. Is a sale, is petition filed under Article 226 of the Constitution of India. Issue notice returnable in 4 weeks. Requisite extra copies of the petition be served on the United State and Departmental Council. Within how much days?
Within 2 days, Lordship. 3 days, by Monday, I'll serve all the copies.
Okay. Within a week, make it within a week from today. Let the concerned records be requisitioned from the Foreigners Tribunal number 7th, Tejpur, Balipara. Next para. Bill for rupees 5,000 to be satisfactory at Superintendent of Police Border, Manipur.
Yes.
Based on receipt of the trial court records.
Item 13.
May it please, Lordship. Lordship, I beg to draw your Lordship attention at page 37 to 41. There is the opinion order, your Lordship.
Which page is the opinion?
Opinion is the page 37 to 41, your Lordship. The contested case, your Lordship.
Where is the 1965 or 66 voters list?
1965 is the page 42, your Lordship.
Hmm?
Page 42.
14.
42, Lordship.
42. Okay.
Three-three-seven serial number, your Lordship. Balumia. Is the father of the petitioner, your Lordship. Three-three-three. Mother of the petitioner, and 334 is the
Just a
elder
moment.
brother, your Lordship.
Just a moment. Yes, not a certified copy. This, but then nothing is available. This 66, 65 voter list
Lordship.
is prepared by the notary, it's not a certified copy. This is not a certified copy. So rightly, the opinion was rendered. There is nothing to connect you. We were thinking that this is a certified copy, but this is not. It's a copy typed by your notary.
Lordship.
No, we'll only give you protection from
Lordship.
deportation. We are not giving you bail.
Lordship, may I draw your Lordship attention? SD LR Das, electoral registration officer, your Lordship.
Ah,
Registration.
you see, we are telling you the document, and if you're not ready to listen to you, why should we spend our time and energy? This is how certified copies are issued. Where they will write, translated into from Assamese to English, mentioned in Assamese certified copy by Satyendra Chaudhary. This is how they will write. As a council, have you seen the certified copy for the first time today? Have you in your career never seen a certified copy?
Lordship, I have gone through, Lordship.
Then why are you making that statement, making us make unnecessary remarks? We are questioning your capability now as a lawyer.
I'm sorry, Lordship.
No, don't do it.
Because this.
Don't do it. We are pointing out to you very respectfully. We are showing it to you, and then you say that it's a certified copy. So therefore, we are questioning our ability as a council.
When enter dates for application receipt.
And this is something we will take serious note of it. Once you say that, you see what you have done is you have also entered. You see, this is a form of certified copy. How did you get it? Then you also fill up form for application 5/1/1996. You also write the date of making copy 5/1/1996. This is creating a fabricated document.
Yes.
We are not giving you bail. We are giving you only not to be deported.
It looks like an attempt to pass this document as a certified copy.
This document has been furnished by the petitioner lordship. No, no, you see, you are a counsel, when you get a document, why you want to ask? And also only have. We only out of this, this writ petition contains, how many pages? 58 pages. We ask you only one question.
Who is Asadul Islam?
Asadul Islam.
The council who has filed it. Who is the council?
He's from Borpeta, your lordship.
Then how can he file it here? Or he has signed it from there and you have filed it here? He has filed it, he has certified these copies to be true copies.
And he has exhibited also, your lordship.
No, no, exhibition is
no.
a different issue, but you have filed it here as a true copy.
That's. No, no, it was.
You have to be careful.
Plus, I'll take care of this. No. Yes, never mind.
I mean.
Hi. We are into protecting you from deportation, not from detention. So A, Diwan, counsel for the petitioner. The respondents are the same. Opinion dated page 3. Before issuance of notice, court is inclined to examine the records of the learned tribunal. So accordingly, the registry shall requisition the records of FT case number 98 of 2017 from the Foreigners Tribunal number 10th, Borpeta. As an interim measure, if the petitioner has not been deported, shall not be deported, then the instead of listing. Next, the prayer for bail shall be considered on receipt of the records from the tribunal. Next, list on receipt of the records from the tribunal. Much obliged.
Well, maybe on the Tuesday we'll have to figure it out. That may put on.
Item 16.
Maybe.
Yes,
Last
you've got
occasion,
the instructions.
No, lordship.
lordship, actually, what happened in this case, my lord, last occasion, my lord, on 39/2024, my lord. And court is granted interim bail, my lord, while obtaining the certified free, my lord. The last part is omission from the order, my lord. And that's why, my lord, yesterday, my.
Oh, acha. Yes, yes.
That is it.
मेरा ना मोटर है तो वो भी नहीं ओ अच्छा सेकंड कॉपी
Yes, no.
We had granted bail.
Yes,
It was not typed here. But Mr. A. M. Ahmed, counsel for the petitioner. Mr. G. Sharma, learned standing counsel for the Home Department. Mr. M. Pudi, learned counsel appearing on behalf of Mr. A. I. Ali, counsel for the Election Commission of India. Mr. H. K. Hazarika, learned government advocate. And Mr. A. K. Datta, learned CGC for the Union of India. Next paragraph. This matter has been listed upon mention made by the learned counsel for the petitioners, who has submitted that on 30/9/2024, this court had granted bail to the petitioner. First of, however, the order granting bail was inadvertently left off in the transcription of the order. Next, consider the submissions made at the bar. First of it is noted that orders were passed in this matter on 31/7/2023, 24/8/2023, 59/2023, and 7/8/2024, and in 24 and 39/2024, and on 4 occasions, direction was issued to the learned standing counsel for the Home Department to obtain and produce a report from the Superintendent of Police within bracket B, bracket close Bapeta. Most of the said report is not yet received. Next paragraph, considering the apprehension of the petitioner that she may be arrested, the court is inclined to grant bail to the petitioner by providing that at the same order, bail 5,000 rupees to the satisfaction of Superintendent of Police Border Barpeta. Next, on the next date, the learned counsel for the petitioner shall inform as to whether the petitioner has appeared before the said authority and taken bail. In the bail order, you also say he will appear before the SP border within 10 days from the, within 10 days. And furnish bail bond of rupees 5,000. Okay, next paragraph, list after 4 weeks in terms of order dated 30/9/2024.
Yes.
Item 17.
Yes, how do you connect yourself with your father
Lordship, I have appended the annexer one. Is a pension paper is under railway department, Lordship. My father was railway department.
Page,
Page 26, Lord.
who is he?
He's my father, Lordship. He's a Badal Chandra De, Lordship. He's a railway employee. And his date of birth is 5/6/1941, Lordship.
Where is the opinion? Opinion is which page?
Lordship, page 68, Lordship. Is the implement.
68.
Yes, Lordship. Is a type copy, Lordship. An order dated, Lordship, 12/12/2003, Lordship. Cornersternal Nalbari, Lordship. Initially IMDT, subsequently its correspondent is a Nalbari FT number 1, Lordship.
You're challenging the IMDT order now,
Lordship, subsequently is a
2003 order.
yes, Lordship. So, Lordship, whatever I had in this case, Lordship, so my residence is absolutely Guwahati, Lordship, as a father employee of the railway, Lordship. So, Nalbari border, Lordship, SP border, issue the notice, Lordship, as a D border, Lordship. So, Lordship, 2005, Lordship, 2003, WS also filed, Lordship, with during the trial, Lordship. And the inadvertent, Lordship, the petitioner is a layman and submitted all documents is a husband, Lordship.
IMDT.
The ex-party, Lordship.
Orders passed. All orders were sent.
You have to take instructions. What
Yes,
has
yes,
happened in
Lordship,
this?
I have taken actually, Lordship, a record is available at DCP Kamrup Metro, Lordship.
Huh?
Record is available at DCP Kamrup Metro, Lordship, that instance.
No, but IMDT orders, what happened? All those orders were recalled and then sent to
Ye-
the,
Yes, Lordship.
what
For
is
the
the status?
typing, password matter, Lordship, for the typing, Mr.
Okay.
Paying has some instruction
Okay.
regarding that, Lordship.
You have to tell us the status of 2003 order of IMDT because
Yes, yes, Lordship.
Uh,
For the
after some
typing,
time.
password.
Yes.
Okay.
Master.
Was there any direction to reconsider these orders? Yes, then you just go ahead.
Pending password.
Item 18,
Yes, what is your best document?
I am before your lordship for the third time. The impugned order, the first one was set aside. Then I went again declared as final. I came back here before your lordship, again sent back. Now, my lord, the last impugned order is page number 70. So earlier, as a base document, as your lordship said, medical certificate, my lord, we annexed it. And we also submitted a petition to issue a commission because the Qazi was bedridden. Subsequently, he died. We also submitted the death certificate. That was denied, my lord. Also, the Gaugura appeared, my lord. There is a Gaugura certificate also. Medical certificate, page number, my lord, 89. Page 89. Sorry, my lord. The divorce marriage certificate.
Where is the opinion?
Opinion, my lord. The last opinion is page number 70, my lord, where your lordship has said that an order from after the report from the Home Department, the case should be decided in a reasonable manner. That report has not been taken into account, my lord.
Where is that order?
My lord, that order, page number
My lord, page number 64, the relevant portion. Page number 64, my lord. Para 6.
Where is that report?
My lord, that report has not been taken into account.
No,
My
where
lord,
is that report?
that report is not there with us. We tried to find with the tribunal, but we were told that we were told nothing basically. And in the order, my lord, in the last impugned order, which is at page number 70, there is no mention about this report from the Home Department.
Okay. But Mr. A.W. Aman, learned counsel for the petitioner. Respondents are same. The by filing this petition under Article 226 of the Constitution of India, Aman petitioner has assailed the opinion dated 28/3/2024 passed by the learned member, Foreigners Tribunal, Kamrup within bracket rural, bracket close number 1 in GFT within bracket R, bracket close case number 1415 of 2017.
Let us call for the record.
Before issuance of notice, the court is inclined to call for the records.
I may be protected in law.
Next paragraph, accordingly, the registry shall call for the records from the records of case number GFT within bracket R, case number 1415 of 2017 from the Foreigners Tribunal, Kamrup within bracket rural, bracket close number 1. Next paragraph. Give bill 5,000 to the satisfaction of Kamrup, SP border, Kamrup.
DCP, I think. Is it?
No,
No,
Kamrup.
SP border Kamrup.
Kamrup, Amingao. With all those conditions. List on receipt of the trial court records of the tribunal.
I'm grateful, my lord.
Item 19.
My lord. Here the my lord impugned order is page number 29, my lord. The linkage document is page number 49, my lord. Jamabandi copy, and it was also the issuing authority also appeared, page 66.
You write so many unnecessary things that we lose track of what you are writing, what you are trying to convey.
I'm sorry, your lordship.
And in the synopsis, you don't write anything. You write your argument in the petition. We can express our dissatisfaction by not granting you bail.
My lord, my sincere apology, my lord. Once actually, my lord, your lordship once said that the synopsis should not be more than one para. So I was
Oh,
following.
that is okay, but in one paragraph also see the write the appropriate things.
My sincere apology, my lord. I will.
You only say some extraneous relevant considerations, and what is those considerations we don't know.
I'll keep this in mind.
Where is the opinion page?
Page number 29, my lord.
Any family member came and deposed in your
Lord,
favor?
the brother, DW2, my lord, page number 65, my lord.
Sukur Ali, his
Sukur.
name is not there with your parents.
No, no, my lord.
Then how do you connect somebody who comes as brother?
My lord, with, sorry, your lordship, the page number 49 in the Jamabandi, my lord. Sukur Ali's name is there.
49.
49, my lord.
It's some different village lordship.
No. Sukur Ali. Sukur Ali.
Nawab Bhita Dityo.
Yes, my lord. Earlier village is lordship, Santoshpur. This is lordship.
This is not there. This is not your village.
My lord, Narar Bhita, this is actually this is mother's, from mother this document came, my lord. I also mentioned this in the WS, also in the evidence, my lord.
Mhm. Where is your written statement?
My lord, my written statement is page number 22, my lord, annexure 1.
22.
My lord, my lord.
Have you referred to your mother's name here?
Yes, yes, my lord. Para 8,
Para
8, para 8.
8. Jalaluddin opposite party name is Sona Bhan.
Sunabhan, my lord.
Now shows from page 50, Sona Bhan. You said it came to your mother.
My lord.
Sona Bhan is rest of 5.
In page 26,
Okay, we are issuing a notice then.
my lord. We have mentioned this in WS, that inherited from the mother.
Okay. Same order, case number will change. Case number is at page 2. I've flagged it.
29.
Bail to the satisfaction of Superintendent of Police,
Chirang.
Border Chirang. Same order as earlier.
I'm grateful, my lord.
Item 20.
No, please, lordship. My lord, impugned expiry order, lordship, it is 48, lordship.
You are coming, 21 order, you are now coming.
Lordship,
Opinion of 2021.
21, lordship.
What is the explanation of delay?
Lordship, actually, on initial dates, I appeared before the learned tribunal, lordship. Thereafter, the COVID-19 came. And after COVID-19, there was disconnection between my learned counsel and me, lordship.
No, I've been.
I was not aware thereafter, lordship.
And lordship, without mentioning in his string lordship, I am declared in expedited proceedings. Where is the opinion? Which page? Page 48.
48. Oh. We live in it. I think. No, no. 19, 20 that will go. 21 will go. 21. Yes, Mr. Sharma. Ex parte order.
Yes, lordship.
Lordship, in the 10th line of the order, lordship, it is also mentioned that my learned counsel also withdrawn, lordship.
Because you have not appeared and taken steps. That is the ground on which he had withdrawn.
That may be, lordship, but
What is the tribunal supposed to do? If you don't appear, your counsel is not instructed.
because of the disruption due to COVID-19, that is.
No, you can make a statement, Mr. Hussain, that as a council, from today onwards, you will never default even if you are not paid your fees. Are you prepared to give that undertaking? We'll send it to our registry. They will keep a record that you have given an undertaking by way of an affidavit that henceforth, even if your client does not pay you fees, you will not make a default.
That
See,
is also
if
one
the
of
parties do not appear, what will the council do?
that is also one of the reality, because these people are.
You see,
very
you are not doing
account
anything. You are not
very-
disclosing the name of the council. Who made the default, whether you are not given a statement that you have paid your fees and the council defaulted. Third thing, you are not saying that there was a contract with the lawyer that the council will come to your home and inform you about the next date, collect documents, take steps, file evidence on affidavit, giving you home service. What's this called? Zomato service. So what can you do?
Chief, I have all other documents in my.
They are giving you protection not to be deported.
Lordship, all documents I do have, lordship. If remanded back, I will hear.
No,
sincerely.
remand can't be like that. We'll have to see the default. We'll have to.
Lordship may kindly protect me, because the details is here in the order itself, lordship. Due to COVID-19, basically, the connection between the petitioner and the council disconnected, lordship. And moreover, lordship, without mentioning any stream, lordship, I am been declared lordship.
It is not clear. Please also clear. This is at page 6. Report. Report. We remanded back.
Lordship. Lordship may remand it, Lordship, but some cost may be imposed, Lordship, because Lordship, he is very much aware about the posting, Lordship. After that, Lordship. Although there was a COVID, Lordship, at that time, Lordship. But after that, Lordship, after 2022, Lordship, no steps has been taken by the proceeding, Lordship. So, Lordship, some cost may be imposed, Lordship, and remand the matter, Lordship.
You did not file WS.
No, Lordship.
No.
Call for the records. Let us call for the records and see what is available.
Okay.
Heard the counsel for the parties. This petition is directed against the order dated 2/11/2021. Passed in FT case number 23 within bracket Roman 3 bracket close / 2019 by the learned member Foreigners Tribunal - Roman 3 Barbados. Stopped. By the order impugned, the tribunal answered the reference ex parte in favor of the state and declaring the petitioner to be an illegal migrant under the provisions of the Foreigners Act 1946. Stop. Being agreed, the present writ petition has been filed. Para learned counsel for the petitioner submits that because of the COVID pandemic situation, which was prevailing at the relevant point in time, there could not be effective communication between the petitioner and his engaged counsel. Stop. The petitioner also could not take steps to appear before the tribunal. Stop. Consequently, the matter came to be proceeded ex parte and the impugned order was passed by the tribunal, declaring him to be an illegal migrant. Stop. It is also submitted by the learned counsel for the petitioner that the petitioner is not at fault or had deliberately evaded from proceeding in the matter by appearing before the tribunal. Stop. Further, the further submission of the counsel for the petitioner is that although the tribunal proceeded to decide the matter ex parte by the impugned order and had answered the reference in favor of the state and had also declared the petitioner as an illegal migrant, illegal migrant under the provisions of Foreigners Act 1946, the impugned order does not specify the stream in which the petitioner has been held to be an illegal migrant, as is required under the provisions of law. Para. Mr. G. Sharma, Learned Counsel for the Department of Home, submits that you'd like to complete his instructions. Para. Before proceeding further in the matter, the court would like to examine the tribunal records. Stop, let the registry call for the tribunal records pertaining to FT case number so-and-so from Foreigners Tribunal 3rd, Borpeta. Matter to be listed after receipt of the tribunal records. Meanwhile, the petitioner will appear. Meanwhile, the petitioner, if not already arrested, if not already detained, pursuant to the opinion dated so-and-so passed by so-and-so tribunal, will appear before the SP Border Borpeta within 10 days from today. And if the petitioner furnishes a bail bond of ₹5,000 with one local security of like amount, petitioner shall not be detained or deported out of the country without leave of the court. Then record the biometrics and other information regarding the petitioner. Extra copies be furnished to the respective standing counsels appearing for the department. List accordingly.
Okay.
She, not he, she.
Act number.
Mr. Datta, where is your habeas corpus matter? Which item?
This item will be called now,
Item 17.
21. 21.
21. We'll take up that because there will pass orders.
Yes. Made, please, Lord. Lord, this instant petition is habeas corpus petition, my lord. Is filed by the petitioner for the release and custody of his daughter, who is aged about 4 years.
But the respondent is the mother.
No, respondent is, my lord, the Biki Hazarika.
Who is he?
He is distantly related with the wife, my lord, who committed suicide due to certain reasons, my lord. And this Biki Hazarika filed a, my lord, FIR. And in view of that, my lord, he was arrested. And during that period, my lord, he came to his residence and took away the various documents. And this his daughter is at about 4 years. And your lordship's consideration would be, if the custody of the child is in illegal hand, in that case, my lord, your lordship will, my lord, interfere in this matter.
Okay. Who's Mr. Hazarika? Mr. Hazarika? You will be appearing in the matter or somebody else will be appearing?
I have not met party. Government has not met party.
forcibly taken away, not only the child, the various documents I am having there, because there is certain business relation with my wife this gentleman was having. Now he was the creditor because my used to do certain business of loan and all that. She took, my lord, the loan from various private party as well as the financial institutions. And when she was not able to pay off, then my lord, there were various the creditors used to pressurize her, and she became gradually depressed and ultimately committed suicide.
But unless the state respondents are there, it'll be very difficult to issue a writ. How can it be enforced? Against a individual, it cannot be enforced, and the court cannot compel. It can only initiate a contempt proceeding if it's not given. So unless the state is there to recover, without the police assistance or the assistance of the district administration.
My lord, your lordship is very right. My lord, in that case, let's do like that. We shall file an, my lord, amendment petition, or my lord, after withdrawal, a fresh petition. It will be better to file a fresh petition. And if your lordship,
Because you'll have to give averments also.
my lord, yes, yes.
And you'll have to also show at the time of at the time of filing of this habeas corpus petition,
My lord.
you had approached the police or the district administration and you did not get the child. No assistance of the state was rendered to you for the recovery of child.
So I think in that
Because
case,
otherwise,
I could get that, my lord. So therefore, let us withdraw this with liberty. My lord, we can file a fresh application.
In fact, there is no prayer for issuance of a writ of habeas corpus.
That your lordship will find the prayer is that page.
Prayer to produce.
Yes. Your lordship sees the
But there is no
at
prayer
page
for-
23,
There is no prayer for a issuance of a writ of habeas corpus.
read to direction to the respondents herein to produce
because
the said
the
child.
it would be ideally to the police to retrieve the girl and bring her under custody, because otherwise it can't be enforced. That's the reason my esteemed brother is asking.
Yes, I could get that. So
Good.
therefore, it is better, my lord, let us
Because
make
that's why my brother is insisting that, you see, the writ of habeas corpus has to be specifically.
rightly, very right.
Because therefore, it is not registered as a criminal record.
Yes.
Registered as WP civil.
That I have seen.
I was wondering why habeas corpus is registered as criminal, as civil.
Civil.
So there is no prayer for habeas corpus.
No, there are many defects, my lord. I have seen that. My lord, can I further pray if it can be, if we can file it in the meantime, it can be placed before the vacation bench.
No, that you'll have to make the prayer before, because the regular bench cannot issue a direction for the regular bench. You can move the registry, it will be taken up.
Yes.
You are always permitted to make a mention.
Yes.
Mr. S. Datta and the senior counsel, assisted by Mr.
H. Das.
H. Das, counsel for the petitioner. Please leave of the court to withdraw this writ petition and to file a fresh petition after including the necessary parties.
Right.
Full stop. The prayer is allowed. This writ petition stands dismissed on withdrawal with liberty as prayed for.
Much obliged.
Time being item 17.
My lord, in this case, probably your lordship was inquiring. My lord, what is the situation, present position of the particular case? My lord, in such cases where in IMDT, the person is declared foreigner. My lord, in that case, that opinion is, my lord, full and final.
Okay.
Yes, there is no ambiguity. If they, my lord, want to prefer a writ petition, they can prefer that.
No, not that. We had heard in the earlier submissions
Yes.
that IMDT orders were all recalled, and then they were,
Not,
in
my
this case, is not
Wh-
recalled.
My lord, where there is already opinion
Okay.
declaring him foreigner, those are not
Those are
recalled.
not.
Those are not. Those
So
are not.
we issue a notice then in this
Yes.
case. What is your explanation to come after so long?
Yes,
Lordship,
that
What
is
is the explanation?
Lordship, I have stated in the para number, Lordship, is 26, page number 22, Lordship. So, Lordship, what happened here in this case, Lordship, para number 26, Lordship, page 22, Lordship. So, Lordship, in the year of 2003, Lordship. So, the petitioner
Para 26, page?
page 22, Lordship, para number 26, Lordship. The operative part, Lordship, is from the fifth line, Lordship.
He is your father,
Yes, Lordship. No,
railway employee,
as a father, Lordship.
father.
Yes, Lordship. Birendra Chandra De, Lordship.
Few things of what you intend to convey, we don't understand. However, the petitioner was an assimilate in respect of the imposing allegation that thwart and discordant. What does it mean?
Lordship, I stated exactly, Lordship.
So you must understand.
Lordship, what happened here in this case, Lordship? In the year of 2005, Lordship, my husband was made an accident, Lordship.
No, that is okay, but we must understand what you are pleading. The petitioner was absolutely layman in respect of how procedure is established to prove from D-voter to Indian citizen, whereas the petitioner being indispensable, all relevant document to become, in half of things we don't understand.
Lordship, I mean to say, Lordship. So, page number 22, Lordship.
No, what is an explanation of not being able to come for 20 years? Because in the writ petition, a thumb rule is that after 3 years, if you come, it may not be entertained even if you lose your citizenship.
So, Lordship, basically.
There must be some explanation. No explanation is there in page.
Lordship, the next page, page 22A, Lordship. So, in the year of 2005, Lordship, so my husband was made an accident, Lordship. So,
No, that is okay. This is 2005. Your opinion is of 2003.
yes, Lordship. So, thereafter, Lordship.
You receive a notice. After that, if you don't appear,
and Lordship,
20 years is a long time to
yes,
interfere with
I
the
admit,
opinion.
Lordship. I admit, Lordship. Lordship, my husband is an auto driver, Lordship. So after made an accident, Lordship, the very financial distress was there, Lordship. So thereafter, Lordship is a very difficult to survive, Lordship. So therefore, in the Nalbari court did not appear, Lordship. So that's why, Lordship.
No, one day you can't appear, second day you can't appear, but for 20 years, if you don't take stock of the proceeding, that means you don't care.
Well, Lordship, as a layman, Lordship, have nothing knowledge in this regard, Lordship.
No, layman is, you see, that is not an excuse. Not knowing the law is not an excuse. Even if she is poor, destitute.
So since 2005, Lordship, not communicate to this court below, Lordship. So this is a difficulty as a layman, Lordship. So I may love to, Lordship, the excuse for the explanation in this regard, Lordship, after.
After 20 years to issue a notice also is very difficult. Not 1 day, 2 days, 20 years. Some explanation must be there.
So
father suffered, husband suffered an accident. We have no proof of what you are saying. You see, if your husband suffered an accident and you say you are a destitute, then you will have to make a statement that you'd never claim MSCT compensation, ever. You neither claimed the government, what you call, accident benefit of notification of 2016 or 19, and nor you have claimed MSCT, and therefore you are a destitute.
I'm sorry for that. As a layman, lordship, on that way,
No,
lordship,
no,
can be
it's not a
excused,
question of
lordship.
layman. You tell us, you state on oath that you never claimed MSCT compensation or accident victim compensation. Then we'll know that you don't know the law. You are a layman.
And lordship,
That statement
the
is not
auto-
there.
accident of auto rickshaw, lordship, as a husband of the petition.
Did you
lordship.
claim any benefit under the MSCT? Any MSC petition was filed?
No, lordship, did not file, lordship.
Make this statement on oath. And number two, we can't believe paragraph 26 because paragraph 26, I always say that I have a habit of reading this affidavit page 25. Paragraph statement made in paragraph 26 is not supported by an affidavit. You merely make 25 to 28 are true to my knowledge. Accident is not true to my knowledge, it's true to record, because there must be some FIR, there must be some hospital ticket. There must be something to say that your husband had taken treatment in 2005.
Yes, lordship.
You say he succumbed and grievous injuries to Maligaon.
You are living in Maligaon, not to file a MSCT case is not believable. Because at least for this, you get home service. There will not one, there will be a battery of lawyers with you. We don't find a reason.
Let the issue notice, lordship.
No, unless you make a better statement, you are not issuing a notice. You'll be dismissing it rather. If you have to say something, give a better statement.
You have to explain to us the statements made in this very long paragraph 26. Most of the statements I'm unable to understand.
Lordship, at that
We
part,
don't
I
know,
have
you're
read,
making some pleading, so we'll have to read
So,
the
lordship, I
pleading.
may allowed to file a affidavit, lordship, additional affidavit.
You do whatever you want. We don't say anything. We just adjourn it on your
Explain,
prayer.
lordship, explain
And if you are
2005,
making a statement, please make a statement which we understand.
Yes, lordship, I may allow to file a affidavit, lordship.
I don't know how you can correct all this. You're making a statement that he suffered accident, succumbed, and suffered grievous injuries. Thereafter, he was brought to the hospital for better treatment.
I'm sorry for that. I may allow to file additional affidavit, lordship.
For the city code.
It is a test on our own ability to read English. That is the least we can say. You have not understood anything you have stated in para 26.
Lordship, since 2005, lordship, there are no
Whatever you have
accident
to
histories.
say,
I
either-
admit, lordship.
or don't make these statements. We are not advising you to do anything, but you have made certain statements which carry no meaning.
Please understand, Mr. Das, we are saying with all humility, it's not a sermon or a lecture. But you see, if you state something in English, if you can understand, if I cannot understand, my brother cannot understand, we doubt our ability to understand English. That leads to a difficult situation. If we can't read and understand something, how can we deliver justice? It must be in a language which we understand. The words must convey some meaning. We don't, half of these things we can't understand. We can read loudly. If any other lawyer can assist us in understanding it, we'll appreciate. But this is something we can't understand.
I'm sorry for that.
If English we can't understand, how will he deliver justice?
It's a little liberty, Lordship. Highly additional
You adjourn it on your prayer, do whatever you want. On the prayer made by Mr. R.C. Das, counsel for the petitioner, the matter stands adjourned today. Or the,
You want to withdraw?
Lordship, highly additional affidavit, Lordship.
you whatever one, we are just adjourning it on your prayer. All the respondents are represented. List after the ensuing vacation.
Pass away.
Item 22.
Yes.
Lordship, adjourn the matter for the timing, Your Lordship.
Yeah,
My
it
senior
will
is
adjourned.
report number 3.
Just a moment, it's an ex parte order.
Yes, Your Lordship.
14. She's deciding this village. She's not presenting a persuasion, give the process of the other. Mr. Sharma, we are issuing notice and giving him bail. The
Yes.
petitioner is projecting that she is resident of the same village.
Yes.
Okay. What is your name?
MD A. Rahman on behalf of AW Aman.
Mr. MDA Rahman, the counsel appearing on behalf of Mr. A.W. Aman, counsel for the petitioner. Also heard Mr. G. Sharma, learned standing counsel for the respondent number
3 and 5, Lordship.
2, sorry,
3 and 5.
3 and 5.
Yes, Lord.
3 and 5. And he shall also take instructions as
Yes, Lordship.
whether he would be appearing for respondent number 6. Also heard Mr. H.K. Hazarika Leonard, government advocate appearing for respondent number 4. Mr. A.K. Datta Leonard, CGC appearing for respondent number 1. And Ms. And Bedi Leonard, counsel appearing on behalf of Ms. P. Barua, Leonard, counsel for respondent number 2. Next paragraph. The ex parte opinion dated 30/3/2024 is assailed in this 24 passed by the learned member from a foreigners tribunal from Barpeta in case number FT 9th within bracket BPT bracket close 370 of 2018 is assailed in this writ petition filed under Article 226 of the Constitution of India. Next, the learned counsel for the petitioner projects that although the petitioner is a resident of the same village, but on transfer of the proceedings as per the process service report, she was not found available, and therefore on return of process, ex parte opinion was rendered. Next paragraph. Before issuing notice, the court is inclined to examine the records of the tribunal. Stop accordingly, the registry shall requisition the record of the aforementioned case from the foreigners tribunal referred above. Next paragraph. The petitioner shall appear before the superintendent of police within bracket border, Borpeta, within 10 days from the date of the order, and on her appearance and on furnishing bail bond of rupees 5,000, give the same order for bail. Next paragraph. List on receipt of the records of the tribunal.
Highly obliged to lodge.
Twenty-three.
Yes, Mr. Ahmed, what is the best document you have?
Yes, my lord, voter list of 1966, 70, 85.
And how do you connect with
Yes,
your
ma'am.
parents and grandparents?
Yes. Ma'am. Up page 75, my lord. Voter list of 1966.
No, voter list is one document. Apart from voter list, how do you connect with your father?
Yes, my lord. Sale date of 1995, my lord.
Sale deed of 95.
Yes.
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 Borabor, Sadek,
92.
Ali, Pitri. Syed. What is your name? Sadek
Sadek
Ali.
Ali. Other name is Soyed Ali. Some discrepancies in occurred, my lord, in the voter list, my lord. When, my lord, voter list of 1989, my
So
lord.
this Sadek Ali, you are the seller.
Sadek Ali.
You are the purchaser.
Yes.
No, but this is post 71 document.
Yes, ma'am.
Which was something to
Petitioner's name for the first time appeared in the voter list of 1985.
1985.
85 or 89?
85.
That 85 was not exhibited.
Page exhibited member. Page 79.
Exhibit N. And where is your father's what is this 66 or 60?
66 page 75. Barnacular is page 76 and 70 voter list is page 78.
What is the name of your father?
Father name is Soyed Ali Milot, serial number 791.
791 Syed Ali.
Yes.
Village is same
Milot.
or different village?
Same village Milot, Kumuli Para.
Mori Para.
Yes.
Okay, we have been issuing notice. This is A.M. Ahmed, counsel for the petitioner. The respondents are same. Opinion at page 1. Here was a giving bill 5,000. The satisfaction of
SP Borpeta.
SP border
Borpeta.
Borpeta. 10 days time to appear before the SP border. All for the records, same order.
No place.
Dipur.
Yes, Mr. Siddhar, what is your best document?
My lord,
parents, my lord, voter in 1966.
But how do you connect to your
My
parents?
lord, my two brothers who are voter with parents in 89, they are examined. Annexer at page 48. Two brothers.
Okay. How did
Ghaznavi
the
and
tribunal
Siddiqui.
deal with it?
My lord.
How did the tribunal deal with this two evidence of two brothers?
Tribunal has picked up a name discrepancy of father, mother.
Where is that? In which
Although, my
place?
lord, there has been explanation.
What is the name of your father?
Father, my lord, in 66 brutalist, father's name is recorded as Samauddin, but in 89 brutalist, it is Saman Ali.
Samauddin.
Samauddin. In some documents, Saman Ali. Some documents, Saman, only Saman. So, my lord, tribunal has disbelieved, my lord. And two brothers who are voter with parents has been examined. My lord. Tribunal held that the names are of different persons. Lordship may kindly have a look at second paragraph, page 73. And brothers' evidence also not.
Just a moment.
My lord.
What is the name of your brother?
Neighbor's mother's name is my lord Ghaznavi, and Siddiq Ali.
Ghaznavi and Siddiq Ali.
Siddiq Ali. My lord, another fact, my lord, he is now in custody, my lord.
Ghaznavi. Ghaznavi. Somehow.
Any voters list with your brothers who have come to depose with you? No.
My lord, brothers, my lord, he is not voter with brothers, my lord. But brothers are.
The question is, how do you connect? Somebody coming and saying that he's my brother, he's my sister.
Brothers are with parent, my lord, they are voter with parent.
Which voter list?
My
Please come
lord,
again.
89 voter list, lordship will
Page?
find at page 48, annexer 8. My lord. Tal Ghaznavi and Siddiq Ali, Abu Bakr Siddiq, they are brothers. And Ghaznavi and Siddiq Ali were examined. Here, my lord, father's name has some little variation, but grandfather's name is same, my lord, Abed Ali. In 66 voter list, grandfather's name is Abed Ali. Here also.
No, Abed Mia, lordship, in 66.
Yes,
Abed. Discrepancy. These are minor. The village is same.
Village is same, my lord.
Then there are age discrepancies is also there, lordship. Age discrepancies is also there.
Age, after all these pronouncements of this court, age, the timing will not. It may come in merit, but now, right now,
Yes, yes.
I think we give some protection to the petitioner.
Notice records. Very good.
And lordship,
So he has there for the petitioner. Name of the respondents is same. Opinion is date is 12/4/2019, page 2. I flagged it. Here issue notice, call for the records,
Explanation of this.
bill
Half hearted.
of rupees 5,000 to the satisfaction of SP border.
My lord, he is in custody, my lord. Custody.
Lordship,
no? Huh? We have filed a separate IAML.
So notice may be issued, Lordship, at this
Record-
stage.
Then we are issuing a notice.
Yes, Lordship.
But her condition is very bad in the proper medical treatment she is not getting in the jail. my lord. That part may be looked into. my lord.
Direct them to.
Okay, bill. There's a IA.
My lord, IA 3142.
It's AS either for the applicant. And respondents are same. Next one, issue notice on this interlocutory application for bail. Just look. The learned counsel for the next paragraph, the learned counsel for the applicant has submitted that as per instructions received by him, she is not having good health. Full stop. And it is
My lord, considering my lord her age, my lord.
she's 73 years. I think
73
we
years
enlarged her
old
on
lady.
bail. She's 73 years. With conditions and
If required, Lordship, regarding her medical status, I can take the instruction,
but
Lordship.
still 73 years,
Lordship.
considering the age, not likely to abscond. Issue notice on this application. The interrogatory application for bail. So notice is made returnable in 4 weeks. Next one. The applicant is a proceedee before the learned member, foreigners tribunal within bracket 10th, bracket was Borpeta. Which is registered on the basis of reference made by the superintendent of police within bracket border, bracket was Borpeta. Which was registered as IMDT, IM within bracket D, bracket was T, case number 7071/B/98. Full stop. On abolition of the IM within bracket D, bracket was tribunal, the reference was transferred to the foreigners tribunal within bracket 10th, bracket was Borpeta, and registered as FT case number 182 of 2016. Full stop. This is a 2019 reference.
19
What
order.
is the explanation?
My lord, I have made a statement in petition paragraph 26. My lord, financial hardship, my lord. And old age
Only saying financial hardship will not be good enough.
my lord, her children are also not taking care, my lord. Poor family of remote village, my lord. Old age, old lady. My lord, husband Prakash. My lord, during the proceeding, husband also expired. The husband expired for doing position. Death certificate in expression. My lord, we have also annexed a death certificate of husband. Annexer 23, page 88. Because of so many reasons, my lord.
No, because you see, that is why the tribunal said that sudden appearance of DW 2 and 3 to stand as witness.
My lord.
That is why it was doubted.
My lord. Yes, my lord. Two brothers were examined.
If your two brothers, family members, your own children are there. There are several children.
My lord.
You have a large family.
My lord, even these people are poor people, my lord. They are living hand to mouth, my lord. Poverty-stricken families.
No, because you see, once you come late, then many things strike the eye.
My lord.
Because the tribunal gave a finding that you had two husbands. And therefore, there's a doubt created that how can a man, women have two husbands? Those things then come to light once you are on time. It's another consideration, but once you are late, many things catch the eye.
My lord, only a humble submission before lordship, considering her health condition and age, my lord.
Where is your voters list?
My lord, she is first time voter in 1977, my lord.
Yes, where is
I
that?
have annexed, my lord.
Which page?
My lord, my lord, at page 82, translated copy, vernacular at page 83, she is with her husband. This is, my lord, first put, my lord.
This is
Page 82. Javeda Khatun with his
52.
82, my lord.
82.
But this is not an exhibited document.
No, not executed. I have annexed, my lord, only because to show her, my lord, present her age and my lord. There are other voter list also, my lord. 89 voter list I have annexed.
Where is her entry in page 83?
83, my lord. 83, my lord. Annexer 2083, my lord. Serial number 257.
257.
My lord. 254 is the father-in-law. 256 is her husband Aziz
257
Khan.
is Javeda Begum.
Javeda Begum, my lord. Her age is 26, my lord. We have also annexed, my lord, 89 voter list where he is voter with her husband.
Okay. My opinion dated 12/4/2019. Where we stop? Stop. Thereupon, by an opinion dated 12/4/2019, It was held that the petitioner is a foreigner of post 25/3/1971 stream under section 2 within bracket small a of the Foreigners Act 1946, who has illegally entered into the territory of India within bracket Assam, bracket close, from the specified territory after 25/3/1971 without any valid document. Full stop. The learned counsel for the applicant submits that pursuant to the said opinion, the petitioner, namely Javeda J-A-B-E-D-A, Javeda J-A-B-E-D-A, Khatun, K-H-A-T-U-N, was taken into custody on
2/9/24.
2/9/2022
Now detention called Gwalpara.
and is presently at the detention center at Gwalpara.
24 is the question.
Next paragraph. In order to explain the delay in approaching the court, it is submitted that the applicant is suffering from acute poverty, which prevented her to approach the court on time. Next paragraph. Considering the submissions made and taking into consideration that the projected age of the petitioner is 73 years, the court is inclined to grant bail to the petitioner by providing that in the event the petitioner is ready and willing to furnish a bail bond of rupees 5,000 with two surety of like amount to the satisfied to surety of like amount, she would be produced before the local surety. Huh? She would be two suitable sureties, huh? Two suitable sureties of like amount. To the satisfaction of she would be produced before by the superintendent of the detention center before the superintendent of police within bracket border.
Arrested by superintendent by police of Borpeta man.
Superintendent of police
Borpeta.
Within bracket border within bracket Borpeta. Whereupon the same conditions, iris and all those conditions will be there. Full stop. Next para. The interim bail so granted to the petitioner shall be taken up for reconsideration when the matter is next listed. In the above, just a moment. Bail of interim bail. Interim bail. That's right. Next paragraph. List along with the connected writ petition on receipt of the records of the tribunal, which is called in the connected writ petition. Two surety.
Two surety. My lord,
22. You said 22. Arrested on 2/9/22.
No, 24, my lord.
24. You said 22, I think.
No, sorry, my lord. I have say 20. I have said, my lord, 24, my lord. 2/9/24.
No, because you said 22. That's why my court master is asking why 22.
My friend, sorry, my lord. If I have committed any
No, it's okay. That's why my court master is also. Because I also dictated 22 and that's why my court master is confirming about the date. Just check it up in the IA. Please check it up in the IA.
My lord. Take
arrested on.
My lord, on paragraph
2924.
Yes, my lord.
Okay,
Yeah.
2924.
Paragraph 3, my lord.
It's okay.
Twenty-five.
My lord, her lordship will find, my lord, the impugned opinion at page 98.
You don't want us to ask you.
Right.
You don't want us to ask you.
And
Yes, which document?
document, my lord, the brothers' evidence were not at all considered by the tribunal.
Where is that opinion?
Yes.
Page
Page, my lord, 98.
19.
Only 98, my lord. 98.
98. Okay, 98. Your brother gave evidence as DW?
DW 2 and 3.
DW 2 and 3.
Yes. That discussion, lordship will find page 101, paragraph 6. How it was, my lord, dealt with. Page 101, paragraph 6, my lord, plus 7 line.
How many brothers deposed? One or two?
Two brothers. my lord.
Two brothers.
Yes, DW 2 and 3, my lord.
One is strong.
Only one is shown. So where are those evidence? Please show us.
My lord, page, my lord, 43, lordship will find.
Page 43.
43. DW 2.
And what are those sealed the registered deeds? What are that? Those the documents of
Registered
stamp
deed, my
paper?
lord.
What is that?
A cell deed, my lord. Lordship will find at page 49.
This is 1940.
My lord. 41.
41.
Between father and another person, my lord.
This is this page 51 is by your father.
My lord.
Oh, okay. This is exhibit number.
This was not. It was not exhibited. It was not exhibited, my lord.
Huh?
It was not exhibited.
Not exhibited.
Yes. And my lord, another more important issue, my lord. Her name has been entered in the latest NRC 2019. That document also, my lord, furnished to the learned council engaged there. Those documents are not also produced before your tribunal.
No, for that you'll have to make a complaint against your lawyer.
Yes,
we are,
yes.
we are
But in the
Sorry.
present case, my lord, we have made party respondent to the concerned engaged advocate also.
here.
Yes. Because case was not properly conducted by the engaged advocate. The NRC where my name has been entered, I am a bona fide citizen of India. Now two proceeding, parallel proceeding.
No,
One
no,
proceeding.
Mr. Mandal, that doesn't impress us. The reason is very simple, that in your writ petition,
My lord.
there is no relief claim against this lawyer. So therefore, he is not a necessary party.
Now,
In a writ petition, a lawyer is not a necessary party because you are not claiming any relief against him. You will have to file if you want, you can file a complaint in the bar council. But this is something we will not hear it because you are not asked for any relief against this lawyer. So you see, I think negative also. You see, as a lawyer, he will come to court and then he will tell us by an affidavit that yes, she gave me documents I did not exhibit. So you want to create an evidence in court. That we will not permit. You pay some fees to the lawyer, he will come here and tell a lie that yes, these documents were given to me. So that is how I think in negative.
Had those documents be produced before the
No,
tribunal,
no,
my lord?
you see, that's why we are saying, had it been a genuine, had you really given it to him, you would have given a complaint in the bar council.
Yes, that is.
But that's why it doesn't impress us. Rather, we'll strike out the name of the lawyer.
Yes, my lord.
Since he's not a necessary party here, he will come and tell in your favor. In this adjudication is not a necessary party. Yes, Mr. Sharma.
Yes.
What to do in these cases when there are witnesses, two witnesses? The tribunal refers to one, does not refer to the second, no discussion.
Yes, Lord.
Do you think this is a fit case to be allowed in motion? Remand it back. No purpose would be served to call for the records, verify, and then find the same thing.
I think it is better to call for the record because Lordship, evidence of DW3 Lordship is
Not even discussed. There's only one line.
It was placed or not, Lordship?
No, you see, we'll tell you why it is, why we're accepting that submission. OPS produced so-and-so as per cross-examination on so-and-so. DW has filed an evidence in form of affidavit. DW has identified as a brother of OP. Statement of his affidavit is so-and-so. Now, DW 3, where is that? Which page is that?
That was not discussed, my lord. At page, my lord, 47.
Page
47.
47.
I think Lordship, it is placed only before the notary public Lordship. That's why I am Lordship requested to call for the records, Lordship.
No. You see, come to page 48.
Yes, Lord.
Come to page 48, certified to be true copy. So he's getting us a certified copy. If it is not there before the tribunal,
Oh, yes,
page
yes,
48 down below.
Yes, Lordship, yes.
He could not have got it. That's
Yes,
why we are
Lordship.
saying.
Then Lordship will remand the matter, Lordship.
Hmm?
30. 35 to be copy. This is 2 to 35 to be copy. Division.
Okay. Mr. M.U. Mandal and counsel for the, we are calling for the records. Let us verify. Mr. M.U. Mandal and counsel for the petitioner. Also heard Mr. G. Sharma, and it's standing counsel for the State Home Department representing respondent number 4 and 6. No, sorry, 4, 6, 7, 9. 4, 6, 7, 9. Mr. A.K. Dattar and its CGC appearing for respondent number 1. Ms. N. Vedil and counsel appearing on behalf of Ms. P. Barua. Standing counsel for respondent number 2. Mr. H.K. Hazarika and the government advocate appearing for respondent number 3. 3 and 8. Next paragraph. In view of the nature of prayer made in the writ petition, we do not find that that Mr. Mohalom, Mohalom Ali, advocate for the petitioner before the Foreigners Tribunal, arrayed as respondent number 11, is a proper and necessary party in this writ petition, as no relief is claimed against the said respondent. So accordingly, the name of respondent number 11 is struck off. Next paragraph. Agreed by the opinion dated page 2. The present writ petition has been filed under Article 226 of the Constitution of India. Next paragraph. It referred to the evidence on affidavit of respondent number 2, but there was no discussion on the said evidence or his cross-examination, and that the evidence on affidavit filed by the respondent number, DW3, within bracket annexure 8, bracket closed, is not even discussed. There is no cross-examination of this
No
witness,
cross-examination.
DW3.
3 was not cross. 3 was not cross-examined.
Okay. Full stop. Next, in view of the said submissions, the court is inclined to peruse the records of the tribunal before issuance of notice. Next, accordingly, the registry shall call for the records of FT case number 376 of 2016 from the Foreigners Tribunal number 5th, Borpeta. Next paragraph. In the event the petitioner has not been arrested, the petitioner will appear before the Superintendent of Police within bracket border, where
Borpeta, my lord, SP.
Borpeta,
Borpeta.
within 10 days from the date of the order, and on furnishing bail bond of rupees 5,000 same. Next paragraph, list on receipt of the records of the tribunal.
Deep obliged.
6.
May I be lordship? May I be lordship? Lordship, what happened in this case, lordship, that the imping order, lordship, page 70, lordship. Page 70, lordship. This is the imping order, lordship. And then Foreigners Tribunal Nagaon, lordship. So here is still lordship. So the school documents has not been proper documents, and the signature is a difficult disparity. On that way, the land court below has passed the imping order, lordship. So I have appended the documents, lordship. Is 23, lordship, is a
legacy data lordship is my father lordship. Yaqub Ali is 23 lordship.
Yes. Recording. We are issuing notice here, Mr.
Yes.
Sharma had Mr. R.C. Das, legal counsel for the petitioner. Mr. Datta appearing for respondent number 1, MS Baby appearing for respondent number 2. Mr. G. Sharma for respondent number 3.
3, 5 and 6.
3, 5 and 6. Mr. Hazarika, respondent 7. This petition is directed against the order / opinion dated 9/4/2024 passed in FT case number NFT within bracket number 3 bracket close within bracket capital D bracket close 1356 /2016 passed by the member Foreigners Tribunal 3rd Nagaon. Stop. By the said opinion, the reference made by the state under section under Foreigners Act 1946 was answered in favor of the state and against the petitioner. Stop. The tribunal declared the petitioner to be a foreign national / illegal migrant of post 25th March 1971. Stop. Aggrieved, the present writ petition is filed. Para. Issue notice, returnable 4 weeks. Since the respondents have already represented the councils have already represented the respondents, notices are waived. However, extra copies be furnished. Steps on respondent 4 by registered post as well as usual course within 2 weeks from today. Let the tribunal records be called for. Registry will requisition the records pertaining to so-and-so case from so-and-so tribunal. In the meantime, petitioner will appear. In the meantime, if not already detained, by the respondent authority, petitioner will appear before SP border Nagaon. And if bail bond of rupees 5,000 with suitable sureties are, one suitable surety is furnished, then the petitioner shall not be detained or deported from the country without leave of the court. When the petitioner appears before the SP border Nagaon, biometrics, fingerprints, and other information be recorded accordingly. List after receipt of the tribunal records after 4 weeks.
27.
May I please, Lordship? My lord,
What is your best document?
yes, my lord, that is 1965, my father's name is voter list, page 18, my lord.
Page 18. Any voter list where you were with your father?
Yeah, and my own name appears in the voter list of the discrepancy in names and address.
We are issuing notice, Mr.
Yes,
Heard. Learned counsel, give all the names. Writ petition is directed against the opinion dated 14/8/2024, passed in FT case number 1357 of 2017, passed by Member Foreigners Tribunal Bojali. So by the state opinion, the reference made by the state was answered in affirmative, and the tribunal opined that the petitioner is a foreigner of post 25/3/1971. Stop. Let notice be issued, returnable 4 weeks. Learned counsel so and so appears for the respondents. Since counsels represent the respondents, notices are waived. Extra copies be furnished within 2 weeks from today. Steps on respondent 4 by usual course and registered post within 2 weeks from today. In the meantime, if the petitioner is not yet detained by the respondent authorities, he will appear before the SP border, Borpeta, within 10 days from today. And if a bail bond of rupees 5,000 with one local surety of like amount is furnished, petitioner shall not be detained or deported out of the country during the pendency of this case. Let the biometrics and fingerprint be recorded along with the other information. List after 4 weeks.
Mr. Mandal, what is it, Mr. Mahmood, what is the name of your father?
Ilimuddin.
Okay.
Ilimuddin. His name is appears in voter list of 1965. In this case, my lord, my father's name appears in voter list of 1965, page 19.
Yes.
And linkage document, lordship may kindly see page 27 and 47.
Page 27.
Yes.
This is not an exhibited document.
Exhibit 27.
Page 27 is not an exhibited document.
Yes, it is not exhibited, but there is the voter list of my brother adduced voter list, adduced evidence as DW2, my lord, page 47, kindly see.
Page 47.
47. My father and his father is the same person.
Is there any voter list of the petitioner with this DW2?
Yes, I think this is there. But my lord, here, entire family's name is also there. Family's name is there. That means lordship may kindly see page 27.
27 is not an exhibited
Not
document. That's why the-
exhibited, yes, not
that's why the
exhibited.
difficulty.
But here, my lord, Brajendra Kumar Mandal Gaura adduced evidence as DW3 page 51.
No, Mr. Mahmood, you are aware. This court has held, Gaura's certificate cannot be a proof of lineage. Have you introduced the name of the brother in the written statement?
Yes, my lord.
Where is
That was there. Page 35, kindly see.
30?
5.
35.
Yes.
Yes, where is the name of your brother?
My brother's name, here entire family's name appears, and brother's name appears. Lordship may kindly see page 36, my lord.
Yes.
Page 36. My father is Kholiluddin.
Yes.
And this actually said the submitted the name of grandfather of opposite party Zahiruddin Mandal. Since this is grandmother of the opposite party Asatun Nesa.
We want to see that the DW2, his name you have disclosed in your written statement.
Yes, disposing. In the written statement, my lord,
Name is not there.
Name is not there, but he has adduced evidence. My lord.
No, that's okay.
That has remained intact, my lord.
No, you see, we are now not examining the evidence. We are trying to find out the perversity. So if you have not named DW2, have you named DW2 in your own evidence on affidavit? In your own deposition?
Let me see.
Did
My affidavit is in page 40, my lord.
Yes, I just want to know
No, 40 is my.
whether the name of DW2 is introduced by you. If it is not, then he's a stranger.
My brother's name is not here.
Not there.
Not here, but Lordship may kindly see one thing that Champa.
No, these
Khat-
names are very, very common. The difficulty lies there.
Yes.
We find it very difficult
Yes, common.
because in a village there may be same named persons more than one.
Here, my lord, one thing is here, my lord. The Mondal.
It is just like there's a cartoon character, Phantom. 22 generations of Phantom we have read. Their names are all
in
Mr. Waka.
Mondal's evidence, Lordship.
Kit Waka.
59 page, for a moment, kindly say Mondal's evidence, my lord. Mondal evidence and this.
So that was discarded for a reason. That was discarded by the tribunal that the Gaura says that he does not know the family. And therefore, court says that the DW3 and DW4 are self-contradictory.
But here, Lordship, kindly see page 29, of course, that is true, but it is a public document, my lord.
Which one?
But that is Jamabandi, where the name of my brother also appears with me, my lord.
Where is that?
Page 29, for a moment, kindly see.
29.
Yes. 29 is the translated copy, and the vernacular is, my lord, kindly see page 31, my lord. 31, 11, Ghulam Rabbani. Page DW2, my lord, Ghulam Rabbani,
Just one.
page 31. And then lordship.
Just a moment. Who has introduced this document? Because this is not an exhibited document.
Yes.
Your exhibited documents are at page 41. Exhibit A is the voters list, B is 1970 voters list, C is revenue paying receipt, D is residential certificate, E is voters list. There's no other document. Come to page 41, 42. That is your evidence.
Yes. 41, it starts from page 40.
Yes, okay, but the
Yes.
evidence is, I'm only referring to only the that
Yes,
are
yes.
relevant. Exhibit A, B, C, D, E. I have shown you all 5.
65, exhibit is 65.
No, I am not on the year. I am on the document. This Javamandi is not a document exhibited by you.
Yes, that's not exhibited. But lordship may kindly believe this was 31.
Mr. Mandal,
Because
no,
it is
Mr.
public
Mahmood,
document.
Mr. Mahmood, in so many years you have seen us. Have you disbelieved any of your statement? Have you found both of
No,
us,
public
both
document,
brothers?
my lord, there are some citations.
No, I am
public-
on different thing. In all these years, have we both brothers disbelieved any of your statement?
Here,
You're not disbelieving.
yes, madam.
But when we are looking at the documents, we are examining the materials available in the record.
Record means, my lord, here, Rabbani's name was 11, serial number 11, and Champa Khatun 15. Champa Khatun is the.
No, those are all post reference entries. We don't have the death certificate of your father. Therefore, what has happened, how these names have come, we don't know.
No,
You
these
see, it's a
are,
post reference document.
no, these are order of the cycle officer is here, my lord.
No, that's okay. But there's a all post reference documents. This we have already seen. This exhibit F, incidentally, is the document. You see, this was introduced. Oh, acha. Yeah. One more question. This is evidence is there. It doesn't include the schools. Okay. I missed it out. Page 55 is an additional evidence where this document is exhibited as exhibit F. Additional evidence, we don't have a habit of reading. Forgot. Exhibit F is a copy of Javamandi. You see, here you say, page 57, mutation of 5/3/2018. The death of your father, you have not disclosed.
Kholiluddin.
No, but death of your father is not disclosed.
It is disclosed, my lord, page 57, para 10.
No, date of death is not there.
That is not there. That is
Therefore,
not there, but
everything becomes
after
very
death
doubtful.
of my father, it is written like this. That is not mentioned. And we cannot expect such type of thing from this type of person, my lord. I'm long back. Here, others, it is that after death of my father, namely Kholiluddin, my brothers Habibur Mundal, Rabbani Mundal, Abdul Hamid, Hasmat, Asmat, Kulson Bibi, including my name, have been mutated on 5/3/18. So that 5/3/18 is that.
18 is post reference. That is the difficulty.
So my lord may believe this.
No, I am not.
Believing.
We are believing the entry also that it is post reference document.
But for linkage, my lord, that is acceptable because otherwise I shall have to take birth before 70.
No, you have taken birth before 70. You said you are born in 1967. Somewhere in your document you have said 1960. You are born in 1967, but there is no document.
So I am very much grateful. Lordship has already pointed out this additional evidence. I am sorry that I could not mention it earlier, but here, my lord, this Jamabandi is mentioned.
Okay, giving you bail. Before puja, we don't want to disappoint you.
Highly obliged, my lord.
Heard. Mr. Remy Manon, learned counsel for the petitioner. Mr. Dotto, K. Dotto, appearing for respondent number 1. And who's for election commission?
Yes,
They've already declared puja. One appears for election commission. Who was there?
Some lady.
And Betty appears for MSP Barwa appears for election commission. Mr. G. Sharma appears for respondent number 3.
3, 6 and 7.
6 and 7. Mr. H. Hazarika appears for respondent number 5. This writ petition is directed against the order dated 16/2/2023, passed by Member Foreigners Tribunal Bojali in FT case number 391/016. Stopped by the state opinion, the reference made by the state was answered in affirmative, and the tribunal declared the petitioner to be a foreigner of post 25/03/1971 under section 2A of the Foreigners Act 1946. Stop. Let notice be issued, returnable 4 weeks. Since the respondents 1, 2, 3, 5, 6, and 7 are represented, notices are waived, however, extra copies be furnished within a period of 2 weeks from today. Steps on respondent number 4 by usual course and registered post within 2 weeks from today. In the event the petitioner is not already detained, the petitioner may appear before the SP border.
It will
Baksa. And if the petitioner submits a bail bond of rupees, furnishes a bail bond of rupees 5,000 with 1 local security of like amount, petitioner shall not be detained or deported out of the country during the pendency of the writ petition. Once the petitioner appears before the SP, the biometrics of iris of both the eyes, fingerprints, and other information relating to the petitioner should be recorded by the SP. Matter to be listed after 4 weeks. Registry to requisition records. Yes.
Mr. Sharma, you are waiting for quite some time. Any matter? Oh, single bench matter. Okay.
Okay. Puja, greetings to all of you.
Thank you.
Yes.
I'm already informed the respondent lordship. I pray for time adjournment to the lordship.
This is being very old now.
Yes.
Okay. Both sides are represented. We get on the joint prayer. On a joint prayer made by the council of both sides. The matter stands adjourned today. List after the ensuing puja vacation on
Lordship,
24, 10, 2024.
one prayer is that lordship, if lordship, again hearing this matter, lordship, there is prayer is matter kindly fixed on 2nd week of November because my senior will be out of station in after puja vacation. He will come on 15 November. So if possible on 21st November, hearing day, lordship. Thursday.
No, because this is more than 3 months old.
Yes, lordship.
You are fixing it on 24th. 24th, there is a single bench. 24th, that day you make a prayer.
Lordship.
Tell Mr. Deka and then
Yes, lordship.
make a prayer after.
Yes, lordship.
Section of.